In October or March of 22, Mr. Weiss was denied the ability to bring charges against Hunter Biden in the District of Columbia. In April of that same year, you testified before the Senate Appropriations Committee that Mr. Weiss was free to run the investigation without interference from the DOJ. According to the IRS whistleblower, there was a meeting in October of 22 where Mr. Weiss said that he was not the deciding official on whether charges were filed. And we know that because we have handwritten notes from the IRS whistleblowers that was confirmed in an email to people in the meeting. Later in January, Mr. Weiss was denied the ability to bring charges again against Hunter Biden in the Central District of California. You testified before the Senate Judiciary Committee in March of this year that he had full authority. That Weiss confirmed that to us in a letter in June, that he had been granted, quote, full authority over this matter. But then he kind of backed up. In June 30th, he said, well, just kidding. My charging authority is geographically limited to my home district in Delaware. And of course, you appoint him as special counsel. So why the heck has his story changed so many times over the course of these investigations?
Congressman, I've seen all of the 3 letters. I've read them quite carefully. They are all consistent with each other, and I urge everyone watching this on television or anyone who's interested to look at those 3 letters. They are not inconsistent with each other, and there's no change in the story.
So, but you agree that he had, and you've said this publicly, that he had ultimate authority prior to the appointment of special counsel?
I've explained this repeatedly here. I've explained this in another proceeding. I said that Mr. Weiss would have the authority to bring a case in any jurisdiction in which he wanted to, and Mr. Weiss has confirmed that he would have that authority. I explained that if he had to bring a case in another jurisdiction, as a matter of mechanics, it would require me me or a delegatee of mine to sign a 515 order. That is very common.
But Mr. Attorney General,
and there was nothing stopping that from happening.
Forgive me for a second, though, but when you say you have ultimate, when he wrote a letter on your behalf in June, I have ultimate authority. This is prior to the designation of special counsel. Ultimate to me means like that you can go wherever you want to.
Ultimate means
at that particular point, sir, could he file charges in the District of South Carolina? He would not have that ability, correct? He would have to go through that U.S. attorney. So that's not full authority.
All he would have to do is ask me for 515 authority, and I would sign it right away, just like when he asked me to be special counsel. Within 3 days, I signed that.
So he didn't have ultimate authority.
He had the authority because I promised that he would have the authority.
But he did not have that authority. See, here's where I'm going. If he was denied the ability to bring charges in March of 22 in the District of Columbia, if he was denied the ability to bring charges in January of 23 in the Central District of California, that's not full authority. These U.S. attorneys operate as gatekeepers, so that's not full authority to do much of anything. And you know what's remarkable to me? We sit here and we look at this, and his story has changed so many times. You know whose story hasn't changed? Mr. Shapley, Mr. Ziegler, the emails that confirm that he said, I'm not the deciding person on whether charges are filed. And you know what the response back was from his colleague at work? Yep, you covered it all, Gary. That is consistent. What Mr. Weiss has done is this shell game and saying that he has authority, he doesn't have authority, but these gatekeepers at the U.S. Attorney's Office in the District of Columbia and in the Central District of California, they would have the gatekeeping authority on whether charges are brought in their jurisdictions.